Maita, you take it away.
Thank you so much. Welcome, everyone. This is the new LA Ordinance and what it means for operations presented by Manzouri Law. My name is Jasmine Aguiar. I am the chairwoman of the board of the Minority Cannabis Business Association, and I myself am a social equity applicant. So we want to dive into what these new changes in the LA market mean. And I have two of the most prominent experts in the industry, Maita Manzouri. Maita, for the last 10 years, has served as a managing partner for Manzouri Law, a firm that has become a pillar for legal resources and one of the most reputable in the cannabis industry in Los Angeles. Maita devotes her full-time commitment to her clients and is passionate about the improvement of cannabis policies in our city. From identifying cutting-edge issues to keeping the DCR and City Council educating and holding them accountable, Maita has been furthering legalization efforts since she began as the federal cannabis criminal defense attorney in 2008. As a cannabis attorney for more than 12 years, Maita is a published author and has represented clients on hundreds of partnership deals, procured licenses for over 300 cannabis businesses, defended thousands of people accused of cannabis crimes, and her tenure includes some of the most seminal cases in federal and state court. She's a mother of 2 young children and an example that women can have it all. Hi, Maita, welcome.
Hi, thank you.
Then we're also joined by Yvette Mcdonald. Yvette is went from city prosecutor to cannabis law. As a former firefighter, paramedic, and retired Emmy Award-winning assistant city prosecutor and trial attorney, she brings to the table years of experience. She has deep respect and value for justice, believes that equity is where justice begins and ends. Described by colleagues as relentless, determined, and a force to be reckoned with, she balances her tenacious spirit with compassion and empathy. Equal justice under cannabis law for all has become Yvette's motto. Her ultimate focus is to educate those in power and make sure that regulation is tolerant in its impact, is inclusive of the entire community. So working side by side with city and county governments to educate and foster economic growth will bridge the education gaps between local government and the community regarding the cannabis industry. As an Amazon's best-selling and #1 international best-selling author, Yvette wants to help create a paradigm shift in the cannabis industry, where equal justice under cannabis law becomes a reality for all choosing to enter this exciting field. Thank you so much, ladies. Welcome.
Welcome. How are you?
I'm doing well. I'm
Good.
doing very well. Excited for these new changes that were approved by Mayor Garcetti on July 10th of 2020. So only a couple of weeks ago, we had a huge amount of documents that were presented from DCR into City Council, and you know, if you ladies got a chance to read all those documents, and we're here to chat about it. Tell us what we as social equity applicants, as community members in the city of Los Angeles and possibly in other municipalities that are going through these challenges of social equity, what can we expect from these changes? What can we learn, and your thoughts behind it? What do we still need to change? So these are definitely topics we're going to be discussing today. To give you a little bit of background to our audience as far as what the background in the city of LA. Oh, here we go. All right. So in 2017 to 2019, Los Angeles was actively legislating cannabis to create a robust regulatory scheme. That included a lot of structure in the city level and the beginning of our application process. June of 2020, a new ordinance was introduced after a year of stagnant litigation due to political and environmental differences. And us on the ground saw that, right? Like, we knew these changes had to happen and actively participated for a year, and we went to rows with no end, right? And then on the mid part of this year, DR presents over 400 pages of literature, and that was passed, which is was passed on July 10th, and here we are to talk about it. So what can our viewers expect today? There was an established process for the issuance of temporary approval for applicants. We're going to learn a little bit of what that process is going to entail. Licenses will be able to relocate, but there's some restrictions and some boundaries that we need to be made aware of. We're also going to hear a little clarification behind the process applicants need to endure in PCN, or Public Convenience Necessity application. The expansion of social equity analysis report. We're also going to talk about the selection process for phase 3 round 2, behind that, and the limit type to type 10 and type 9 licenses for social equity individuals, and type 10 and type 9 are storefront retail and non-storefront retail. And there was an expansion to the definition of equity share. So we're here to learn about what expansion means to us as social equity applicants. So welcome everyone. You also have the opportunity to submit questions. Shannon, who is in the background, is definitely taking track of that. So if you have any questions, please submit them in the chat box, and we will try to get to them as soon as possible. We're also going to have a Q&A after we get through the meat and potatoes of this information. So please continue to be engaged and ask away. So take us into this first section. We've, as applicants and license holders, have been stuck in a position where we cannot relocate into another property, right? And there's a lot of background as to why we need to relocate, and there's differences of why it needs to happen. But now we have a who, where, and how. Can you ladies discuss what are those key points of who can relocate, where can we go, and what is the process going to look like?
Okay, I can take that one. So who can relocate? This is something that's been an issue that we've been advocating for a long time, because unlike any other business, cannabis businesses have been limited in that they cannot relocate. And just recently, like Jasmine said, about 2 weeks ago, it became law that the DCR is allowed to now accept relocation requests. Those requests are not available yet, but they will be soon, according to the DCR. So these are the basic rules for relocation. Essentially, if you have a one of the license types that's not subject to undue concentration limitations. So if you have type 6 non-volatile manufacturing, a delivery, which is a non-storefront retailer type 9, or distribution license, you are able to relocate your business, that license, to any location in the city, which is great news. Very excited about that. Cultivation and volatile manufacturing and retail storefront is more limited, and you can theoretically only move within your same community plan. Now, that's if your community plan has reached undue concentration. We know what that looks like more or less. Well, actually, we don't for retail anymore. We did before, but so we don't really have that information. But due to the fact that phase 2, over 1 million square feet, were licensed beyond the undue concentration limits and caps, we don't think that many community plans will be available to sort of switch because most of them probably have met their undue concentration limit. But we don't have that information yet, so it's not for certain. What is for certain is that you can probably relocate within your same community plan if you have cultivation, retail, volatile manufacturing. Obviously, nobody has a volatile manufacturing license in the city of LA yet. One interesting and exciting thing about this new ordinance is that phase 1 and phase 2 licensees can bifurcate licenses. During phase 1, a lot of existing medical marijuana dispensaries got 2, 3, 4 license types, and they were sort of married to their location for those license types. Now they can start moving those around, and the same goes for phase 2. So theoretically, if you have, not theoretically, but if you have a phase 2 non-retail license and you have manufacturing, distribution, and cultivation, you could move your manufacturing and distribution anywhere in the city that you want and keep your cultivation at your current location, or move your cultivation to another location, but probably within the same community plan. So that's kind of the lowdown on the relocation, which is a huge change and an exciting one. The amendment forms, I don't believe are available for that yet, but DCR says that they will be soon.
And Vital, if I could just add one thing to that, people need to be aware that there will be a fee for any of these amendments, forms submitted. There will be a fee for everything. So just get ready for that.
Yeah, and it just came out recently that they're looking to change those fees. So in the new ordinance, it makes reference to certain fees that aren't even actually in the fee table yet. So that's going to be a big opportunity for us and for stakeholders to give DCR and the city feedback, because those fees can really start to add up, and we want to make sure that you are not getting, overtaxed, or, it doesn't amount to an unnecessary tax, that it's actually a fee that is necessary for the actual change. So keep an eye on that.
Thank you. And the next question is, what are the limitations to people that want to stay in their location? Like you mentioned, keeping a retail and a cultivation in the same area. What are my limits? What can I do? What can I not do?
Yeah, this was an interesting addition to the ordinance that we're not quite sure what motivated it. I don't know if it's because, and Yvette, I don't know if you know, but if it's because of inspection reasons or what, but they've if you want to relocate, you can essentially go as big as you want. But if you want to stay in your current location, you're limited to expand only 500 square feet or 20% of the existing floor area, whichever is less. And seemingly that's governed by the premise diagram that was submitted with your application. So this is something to watch and maybe be vocal about if it affects you. We're not quite sure the motivation for this, and we're trying to get clarification from DCR on it. A lot of people were scrambling to get ready for inspection, and so they only submitted a partial premise diagram so that they could be inspection ready. But that was kind of like phase 1, and they're waiting for, just to kind of continue to develop their space, and now they're limited in this way. So that was something that I'm not sure what the motivation was, and it's kind of limiting.
Yeah, I agree with you. I've learned not to speculate, try to figure out what the motivation was. Just come out and ask the question. And I think that's something that people would love to hear. What's the motivation behind the changes here? So who knows? Unless DCR comes out and tells us, who knows?
So
Okay.
anything you want to add to these limit modifications? I think, you know, we need our audience to get involved in asking these questions to DCR and City Council. What can you go to the next slide? I think we skipped one, did we?
I think, let's see, we did limitation on premise modification, ownership changes. This was just another quick update. Yvette, did you want to speak to this? I don't know if I heard you jumping in there.
No, I hadn't jumped in yet.
So ownership changes, again, you can file an amendment, like Yvette said, there's also fees associated with filing an amendment. And a new kind of twist on this is that if you're selling the business outright, meaning that the existing owner is selling all their interest to a new owner, that's actually going to validate the license, and a new application will have to be filed. So there can only be partial sales from this point forward. And that's something that's kind of already existed at the state level, and there are ways that we deal with that at the state level as well. So it's not fatal, but it does require some maneuvering through the regulations. If one existing owner is retaining their ownership, and if you have, for example, two partners and partner A sells everything to partner B, that's fine. That's not considered an ownership change when you're bringing on a new individual or a new entity.
Awesome.
Just keep in mind that any type of ownership change is going to have to go through the approval of DCR as well. So
Yes.
It's one of those things that you might want to ask the question first before you consider that. Because if you get down the line and you want to start an amendment and you want to pay fees, and at the end of the day find out that you could not make that transfer, then it creates an entirely new set of headaches. So ask questions prior to. That's the one thing that I would add to that.
That's a great point.
Yes. So great segue into our next question, Yvette. I want you to expand a little more about what ownership now has a new meaning in social equity. So equity share, there's a new definition in the ordinance, and that goes back to ownership. So, but this equity share is specific to the social equity applicants. Can you give us what the background on this is, what the new changes are, and how is it going to affect us?
Yeah, well, my belief that the changes came about as a result of what happened prior. And when I say prior, when we had the licensing process start in September, and we saw applications go in where the equity applicant was diluted, their equity share of 51%, or maybe even a 33 and a third percent was diluted. And this created a lot of problems as you were going through the agreements, looking at the structure, really trying to figure out what the true equity share percentages were. It wasn't clear because you did not have enough information to make that determination in many of these agreements that I saw. So a lot of feedback was given to DCR about this, a lot of complaints. I just heard continual complaints from equity applicants. So that is my belief as to what prompted this change. And, you know, we now have the new definition for a social equity individual applicant. This is a whole brand new thing when you're looking at that. And they still have to comply with the equity share criteria. Nothing has changed in that respect. But when we talk about ownership percentages, let's be real clear that a Tier 1 social equity individual applicant shall own no less than 51% equity share. Okay, that's very important to keep that in mind. No less than 51% equity share in the person to whom the license is issued. So you just have to know there's that license out there. You are engaged in some respect, but still, based on your definition and the character that you are holding right now, 51%, and a tier 2 social equity individual applicant shall own no less than 33 and a third percent of equity share, again, in the person to whom the license is issued. So those things are also, I believe, opening up Pandora's box to create some issues as well right now. I've talked to several applicants and they've gone back in to try and renegotiate their agreements to encourage, and I'm going to use that word lightly, to encourage the investor to comply with the new equity share changes. And they have been met with resistance in that respect. So we are going to see, I believe, a lot of back and forth with this, and DCR, they're going to have to get involved to help resolve some of this stuff. As you see, we have voting rights, where the equity applicant, they must have at least their equity share percent of the voting rights. This is another area where before you saw voting rights diluted. When you see a board of directors that has been established, and within that board of directors, the majority of the voting was given to people who were in partnership with the investor. So it really left the equity applicant on the outside, even though they were told they had a vote and it was supposed to be a super majority vote. At the end of the day, no. The voting came down to the majority of people who agreed upon a particular topic, yay or nay. So we have to look at all of this stuff and stop playing the semantics with words, and really just call it out for what it is. You got to comply with the rules. We're also talking about now a highest officer position, which has been outlined as well. And it talks in particular about that 51% social equity individual applicant holding the position of the highest office when they come in, and that could be the CEO of this business. But at the same time, if the social equity applicant agrees with the partner to bring someone or allow someone else to assume that position of CEO, they can do that. So it's not as if someone else can't be CEO, but if the equity applicant decides that that's what they want to do, that's the position they want to assume, then rightfully so, they have been given the authority to do that in this new ordinance. So it's something that you want to keep in mind moving forward. And I know the investors are not going to like that position of an equity applicant saying, hey, look, I'm 51%. I want to be CEO. Therefore, what are we going to do about it? Another source of contention is going to happen, which I'm already seeing. Let's see. I believe that the majority of what we are getting ready to see is going to be a renegotiation of agreements here. So the equity share guidance will be complied with. And when we see that, the question for me is going to become when an investor says, no, I am not agreeing to this. I know the city has put in a new ordinance that the equity applicant now has a right to go to court to try and enforce the provisions of the equity share. But prior to that, what I want to know is, will DCR get involved to prevent this? Because the equity applicant typically does not have the money to go in and file a lawsuit against the investor. And I don't believe the investor really wants to have a lawsuit filed either, tying everything up in court. So we need to see some specific language where DCR says that they will resolve this issue. And the only way you can resolve this issue through equity shares is through comprehensive vetting. You have to vet these agreements and really find out if the equity shares have been diluted. The only way you're going to determine if they've been diluted is to look at all of the agreements that accompany, to find out these ancillary agreements, what do they look like, what type of percentages are being charged, management agreements, all of this stuff. So, you know, this is where I really see the issues coming down. Management companies as well. Are the management agreements going to be approved by DCR? I think that was language that was removed from the prior ordinance. Why was that language removed? DCR needs to vet these management agreements as well to make sure that everyone is in compliance with what needs to be happening. Something real interesting struck out to me with an agreement that I looked at, and it was a management agreement. When they talk about ownership, and I know the magic number is 20% or greater, you're considered an owner. And the definition, when they lay it out talking about an owner, which is found in the Business and Professions Code, that first definition, there are 4 requirements. And under that first one, when they talk about the 20% interest, this is all I hear about. But when you go down to B, C, and D, there's another definition that is critical for this, and it's tantamount to describing and defining characteristically an employer-employee relationship. And this is also what I'm seeing in these management agreements, where it's almost as if equity applicant, you are under my thumb to do what I say, how I say do it. That is typical in an employment arrangement, employment relationship. I've been an independent contractor for quite a while, and I know that there are specifics that you have to deal with in making sure you stay within an independent contractor's definition, because if not, you're going to roll over into an employer-employee relationship. And that's the same thing that I've seen happen with these management agreements. So again, I see a source of problems happening right now. So those are some of the things.
Thank you. I have an audience question, a couple actually. There are, of course, a lot of issues between social equity applicants and general partners. Our audience wants to know if there's a way, or if we are figuring out a process where the social equity applicant can continue having their social equity share and transition that general partner out and possibly transition a new one in.
I can take that, Yvette. It's a great question. So the way that I understand the question is, if an ownership can be done with the non-social equity
license.
Yes, they can. That's an ownership change that would have to be done and get approval from the DCR, but that can be done. The only sensitivity is with the social equity applicant, especially with regard to phase 3, round 1. Sorry if you guys are getting feedback on the audio. Yeah, it sounds weird. Maybe if I make this mute. So the non-social equity applicant can be changed out. It's the social equity applicant that has to stay, or a social equity applicant may be able to sell their ownership to another qualified social equity applicant of the same tier.
Sorry.
But everything obviously requires approval and a fee with the DCR.
Thank you very much. Yvette, do you have anything to add to that equity share transition?
Yeah, just make sure you confer with DCR if this can happen. You know, I can't emphasize that enough because some of this language is a little bit tricky, a little bit confusing with some. You want to clarify everything you do with DCR. prior to. That would be the best suggestion that I would have for people.
Thank you. My next question from the audience is clarification on what a tier 1 can own. We know the limit or the minimum is 51%, but the audience wants to know, can they negotiate more than just that bare minimum?
They can.
There's no restriction on that. It's not a maximum of 51, it's a minimum.
Yeah, so they can, you know, if whoever they're in partnership with, an investor, if they want to give up more than 51%, there's nothing to stop them from doing that.
So I could potentially negotiate a 80-20 where I, as an applicant, am a 80% equity shareholder and my investors is 20%, which under state regulations would still consider him an owner and have to go through the due diligence. But my majority is 80, not 51.
That's correct.
Thank you for clarifying that.
And make sure that that is spelled out in the agreement. Anything that you are going to agree with, there are no rooms to assume anything. Spell it out in the agreement.
Thank you. Any other thoughts when it comes to equity share from you ladies?
There was one other thing I wanted to add when we go back to this. I think we're going to talk about it more in the next slide, but really, you know, equity share, the evaluation of whether an equity share is being encumbered is kind of the test here. And we're hoping that we're going to get more guidelines from DCR. We're working, you know, both Yvette and I are kind of trying to figure out how to come up with some better guidelines alongside the LA Cannabis Bar Association and the DCR. But, you know, I would say that one sort of telltale test is, where's the money going? If you have 51% and the company is making millions and millions of dollars, but at the end of the day, you're getting a $5,000 monthly salary, that may or may not pass the smell test depending on where the money is going. So if you have a management agreement, for example, that charges reasonable management fees, then great. But if the management company is essentially just a tool to funnel all the money out of the entity and away from the equity applicant, then that might not pass the smell test. So right now, I think we're kind of at a sort of case by case basis, unless and until we get more guidelines. But you know, the money is kind of very indicative of what's going on here. And then when it comes to management agreements, so I think in the new ordinance it says that a management company shall not hold an equity interest in a licensee. So it sounds like a management company cannot be any equity owner of the company, not just 20%, but we got to flush that out a little bit. And then one really important thing to note is that whatever the management company does, the licensee is liable for. So you want to make sure that if you are engaging a management company, you have some oversight, you know, management agreements. I think we have an article with a bunch of tips on how to negotiate a management agreement. And you want to make sure as the business owner that you have some oversight on some of those major and critical decisions from the management company so that you don't end up losing your license as a result of the management company's actions.
Absolutely, Mital. And what I want to add to that, when you're looking at these agreements, this is one of the reasons why I am such a proponent of seeing all documents involved. As you're moving forward in any business transaction, I want to see an MOU. I want to see a pro forma. I want to see your organizational structure. I want to see who's on those documents. I want to check with the Secretary of State to find out if in fact that company is still operating lawfully. Have they been suspended? I want to see everything, because this is the only way that you are going to effectively determine whether or not these agreements you're entering into are in compliance with the equity share guidelines. And I know DCR requires certain informations to be given, and on the face of that operating agreement, it may say, okay, I'm going to give the equity individual 60% and whatever it says on there. Those are numbers. Those numbers mean absolutely nothing unless you see the other ancillary agreements to go along with this. How do I determine, and I'll give you an example of an agreement I'm looking at right now that gives the equity applicant 81% and the investor 19%. And my first question was 81% of what? What does that mean without any supporting documents to make that determination? And if I don't have that, how do I know that this is what it means? I've seen agreements, I've seen pro formas, and one investor, for example, after going through all of the ancillary agreements, after all of the hard expenses have been deducted, at the end of the year, the investor was taking home $570,000 in profit, the equity applicant $88,000. You tell me that's a 49%? Come on. It's time to get real with this stuff, and it's really time to evaluate these agreements, whether people like it or not. This is just doing business the way business should be done, and not trying to circumvent the system by doing this. And I call on DCR to evaluate these agreements, to vet these agreements. This is one of the reasons why the LA County Bar Association, we are putting together now a group of attorneys who can come in and donate some time to go through some of these agreements. This is going to be critical to the survival of every social equity individual applicant, because it's your legacy that's being messed with here. And if we don't do it right this time, then you will see problems happen.
I agree with you. I think that, we've seen these problems kind of add up through the process of social equity applications. And you ladies mentioned there's a lot of unclarity when it comes to what that ownership looks like, and accountability, right? Like checking off and reviewing these agreements. What other things are still unclear that we need to be aware of, and what does DCR still need to do?
Well, for
we
me,
could probably have a whole webinar on that, but
in regards to the equity share, so
yeah, the equity share, there's a lot of question marks still, and I assume, and I'm hoping that DCR will provide some further guidance, and we're all sort of figuring this out, but the issue of unconditional ownership, that you can't divert the benefits of ownership, we need further guidance from DCR as to what that means, kind of what we talked about before, which is what does encumber mean, and kind of following the money and the smell test and all that sort of stuff. But it's uncertain whether DCR is actually going to give out further guidelines, or it's just going to be a case-by-case basis where they're going to be evaluating these agreements, and it's going to be up to the individual parties to negotiate, execute the agreements. And then what I kind of foresee happening is, at some point there may be a dispute amongst the partners, and at that point the social equity applicant may raise a red flag for the DCR and say, hey, I was screwed over in this deal, can you guys help me out with it, or whatever the case may be. One thing that the ordinance is completely silent on is loans, and that is a huge hole that can be exploited. And so that's something that we really need to see further guidance on. What what loan terms? Can you get 3 times your money back? Can you get 4 times your money back? Are you going to be entitled to repayment first? What are the terms here? And, you know, we did some research and we tried to kind of see what other areas of the law you could make analogous to this situation. And it seems like, and maybe this, I don't want to speculate, but it seems like some of the DCR language came from the Small Business Association loan program to disadvantaged individuals, which has a lot of the same language. And in that particular section of the law, a loan is authorized and a license can be used as collateral. So that means that if I loan you $1 million and you default on the loan, I can use your license as collateral. The only issue there, obviously, is that if I don't qualify for social equity, then I would be in violation of the equity share requirements under the ordinance. So it's muddy for sure. And, you know, the investors need some sort of certainty, which is understandable. And the social equity applicants need to be shielded from predatory loans and predatory practices. So it's a really fine line to walk. And we're hoping that we'll get a little more guidance, or at least some sort of template, or, you know, this is, you know, absolutely not allowed, and this is absolutely allowed, and here's some of the gray area. You know, that would be kind of nice to have some clarification on. For right now, for where you are right now, if you're a phase 3 or a phase 2 social equity applicant, you need to be having serious discussions with your partners and your lawyers about, you know, how, if, you know, what we're doing is we're conducting an audit of each contract and each agreement, and we're saying, okay, red line, this is absolutely non-compliant. This is absolutely compliant. This is in the gray area. So whenever you're in the gray area, that's where that was suggesting that you can kind of fly that by DCR and see if you can get the blessing or some sort of further guidance. The other one that seems to be an issue is the successor and interest issue. So if God forbid something happens to the social equity applicant, what happens to their interest? Well, under the ordinance, it's clear if that applicant is married, then the interest can go to their spouse and you're not in violation of the equity share agreement. But if you're unmarried, it's a little bit less clear, and we need some clarification there. And that's kind of, I think, one of the biggest points of issue here is if I'm unmarried and I pass on, but I have 2 children that I'd like to leave my interest to, but my children don't qualify as social equity applicants, how is that going to be handled? And there are some options and some creative solutions, but we're still not sure if that's going to pass the equity share muster at the DCR level. And the last thing you want when you're passing on your interest is for your next of kin to be stuck in court battling over equity share and what qualifies and what doesn't qualify.
And I agree with you on that, Maita, that is going to create some problems as well if there's something that happens. And again, this is stuff that needs to be spelled out in the document in the event of death or incapacity. What's going to happen in that respect? You know, who do you choose? Because you certainly can't do it after you die. Or many times if you're incapacitated, that's not the time to think about, well, who's going to assume my equity interest here? You have to do this stuff up front. And that is why it is so critical to have attorneys go in and really negotiate these agreements for equity applicants. You have to have that. You can't just have something put in your face and told that you have an hour or an hour and a half, which is what has happened in the past, to go and find legal counsel or say, well, if you don't sign this, then you move on. No. That's not the type of business relationship you want to have or you should have. You need to have someone there who is going to advocate for your best interest moving forward.
Thank you. All great points. So next slide, we want to wrap up and with this question, and what are the consequences? What happens if some of these new provisions are violated?
In the ordinance, yeah, go ahead, Yvette.
I was going to say, yeah, the denial, revocation of a license, remedies in court. But once again, if we, for example, if we have a situation like I believe we're going to see, where investors do not want to comply with the equity share guidelines, then this is going to be an issue that DCR needs to step in. And again, the only way you are going to determine whether or not the equity share guidelines have been violated is to have all of the documents. You have to have those documents to be able to get an accurate accounting of the monies that we're looking at, the percentages. I can't tell what percentages of equity share are there if I don't have all of these documents to base that on. And going to court, if that is supposed to be the first remedy for the equity applicant, I don't see that happening either. I think that that is very cumbersome on someone who's already depending on an investor for money. And I don't really see the investor giving an equity applicant money to take them to court to enforce provisions of an agreement. This is where DCR must step in, and we must go through these applications in order to make that determination. And then let DCR tell the investor, provide document A, B, C, or D so we can go through these things and save a lot of headache. Let's not put the burden on the court to do something that DCR should be doing.
Thank you. And you know, that transitions us into our next set of questions is these ownership changes are now going to be applied to phase 2 and phase 3. And as Maita mentioned, you know, there has to be an audit, right? And check your agreements, make sure that they are aligned with these new changes. And I want to talk now about this new changes that affect phase 3, which was in DCR, the first round of actual retail licenses for social equity applicants. And in the last year, the phase opened around this time last year, and we saw a flood of people trying to align themselves to submit an application come September. And now we've moved forward with some resolutions. What does that new ordinance mean for those who were invoiced in phase 3, round 1, and those who weren't?
It's been a long road for these folks that, you know, were invoiced from phase 3, round 1. And after the audit and the new ordinance is finally in effect about 2 weeks ago, they have a pathway to temporary approval. Temporary approval is something that was available to phase 2, and it's now available to phase 3. It's slightly different in phase 3, round 1 than it was for phase 2. You have to get a state authorization in order to get your local temp approval. So those folks that were invoiced, you can start applying for your state license now, and presumably when the state calls DCR to get you know, the blessing from the local authorities, as is required by state law, you know, the invoice should suffice. Your business premises has to pass an initial inspection. You have to pass also a fire safety inspection. You have to file some required attestations. What that means is that you know, you'll indemnify the city, you promise to follow all the rules, et cetera, et cetera. And then you should be on your way to getting temporary approval. So the multi-million-dollar question there is, what's the timeline? At the state level, the timeline for getting a new provisional license can vary, but it can be done in as short as 1 month, and it can take 3 months. It can take 6 months, depending on how prepared your documents are. And at the state level, you'll need all your SOPs and your premise diagrams and all that stuff. So you want to make sure that all of that is complete when you submit it to the state, so that you don't have to go through a bunch of rounds of back and forth with the state to make sure that you are approved.
That's very exciting news. City of LA is moving forward with opening up new retail shops. We've been in a pre-ICO era for a really long time, and I think everyone's very excited to see new stores and have more accessibility as consumers. There was people that unfortunately did not make the cut, and although there was a lot of controversy during this process, DCR has come up with a couple of solutions with the people who did not make it to the first 100. What can those people expect? What's in the horizon for them? Yvette, do you want to talk about?
Well, yeah, there's the offer of delivery licenses. When that's going to happen, who knows? We can throw that up in the air. There's always applying for round 2. We have no idea when that's going to happen either. So there's a lot of uncertainty here. And for those people who are sitting and waiting to hear further instructions as to when delivery is going to open up, they're waiting just like you and I are waiting. I have no idea. I wish DCR would come out with a date that people can get ready for. I wish delivery would have been included with these changes, so they would have become available immediately for people who did not make the cut. Because a lot of people have spent a lot of money. They've lost a lot of money. What delivery would have done was given them an opportunity to now recoup some of their investment that has been spent. So, there's a lot of things, but what's going to happen, the time frame that it's going to happen, I have no idea. I've not seen anything other than 2025 date that's mentioned, and we're looking at what, 5 years, 4.5 years from now? Come on, that's ridiculous.
Yeah, one sort of reprieve for some of these folks obviously is the additional 100 invoices that are going to be issued. And to Yvette's point, we're not quite sure about the timeline on that, but I think DCR has said later this month. So if you did apply in round 1 and you were not invoiced, but you might still have a chance if you're in that line of the next 100. And how that's going to be calculated essentially is we have our first 100 that were invoiced. And within those 100, you've got folks that were deemed ineligible for further processing. And they were deemed ineligible for further processing due to various factors. If one of those factors was either a competing licensee, a license or an invoiced applicant within 700 feet, then they will get a second go at this, if that makes sense. So essentially, if your business, if you were number 3 and number 1 was within 700 feet of your location and got an invoice, then you were deemed ineligible for further processing. Now the DCR is going to go back in line and tell you, hey, now you get an invoice, pay that invoice within 10 days and find a new location. How long do you have to find a new location? That is uncertain. But it probably does have to be within the same community plan. Once they go back in line and get through those numbers, oh, the other issue that maybe your community plan reached undue concentration. So if there were 7 licenses available in Boyle Heights, for example, and they filled up and for that reason you were not invoiced, but you would have been because you were in the top 100, now you're going to get invoiced because essentially the new ordinance kind of resets all those caps. So that's a really interesting development there, and we'll see how that plays out, but it's kind of exciting. Yeah, so, if you're probably, I think they got through to 148 to invoice 100. And so I think maybe there's, probably 20 or so in the first 150 that will now be deemed eligible for further processing. And then arguably another, these are not exact numbers, but another 80 or so will start counting up. So if you're number 200, you probably have a pretty good shot. If you're number 700, probably don't have a pretty good shot and you want to start thinking about delivery or round 2. Yeah, I think that kind of covers that. And then like Yvette said, those that are not processed will have priority for delivery, and round 2 will be a lottery. So they're not going to do first come, first serve anymore. They're going to do a lottery that's going to be open for 30 days.
Thank you.
Yeah, sorry.
So I do have a couple of audience questions in regards to phase 3. The first question is, can we open our phase 3 retail round 1 facilities already if we have been invoiced?
No,
No.
not yet. You need temp approval first. So back to the slide where you need to get you need to check all these boxes first to get temp approval, and then you can become operational.
Thank you.
At DCR's discretion, right?
Yeah, so the city hasn't opened up for us to go through this process, and we're just waiting for that process to start, and then yes, we can open shop.
Yeah, what you can be doing is applying for your state license now.
The next question is, are the tier 1 social equity applicants already qualified without a cannabis arrest or conviction able to participate in the phase 3 round 2 lottery?
Great question. So for delivery, you can have what they're calling sort of the old qualifications or the new qualifications. For round 2, you're going to need the new qualifications.
Yes. And you will be characterized as the social equity individual applicant. And so going through looking at that, they have those requirements laid out in the ordinance, 2 of the 3 that you need to qualify for or qualify under. So that's pretty clear when you go in the ordinance and look at those things.
Thank you. And last question about phase 3 applications. Is the PCN process open now for new applications?
You can submit a PCN application right now. None of them have been processed any further. Essentially, we're waiting for DCR to come out with some new guidelines on PCN and for City Council to adopt those guidelines. And so you can submit the application, you can get yourself in line, but you can't actually be processed yet. And I don't know when they're going to start processing those.
And one of the things to add to that also, it would behoove you to find out who your council person is and strike up a relationship with them. It would behoove you to find out who your neighborhood council is, introduce yourself, find out what's happening with them. Do all of those things that are going to be required of you to do anyway, set the groundwork for what you want to do. Don't wait until the last minute. You need to start doing this now, because at the end of the day, you're going to have council approval for the PCN process, and in particular, your respective council person. You really need to build that relationship with them and find out where they stand on this, because you're going to have to deal with them anyway. So why don't you start the process now?
Yes, and you can find some of this process if you visit cannabis.lacity.org, and great information on what resources are available, the ordinance, and the process of application. I do have another question in regards to phase 3. Can phase 3 applicants who have been invoiced relocate their retail location?
So many good questions. Yes, I mean, once relocation becomes available, that is an option. You will have to do it within your same community plan, maybe. You know, although there does seem to be a legal argument for you being able to move outside of your community plan now that you're not subject to undue concentration anymore. So that's something that is a question mark and still to be developed, but you probably won't be able to request relocation until after the second 100 gets invoice processed, maybe has some time to find the location. So it's probably going to be possible, but it's going to take some time.
Great, great.
Contact DCR.
Yes, contact DCR.
Contact DCR.
There is one more phase 3 question. There is an applicant who was deemed ineligible and dissolved the entity. What happens to their application after this round 3 continues to be processed?
So Jasmine, was that they dissolved the partnership?
Yes, it sounds like their application was or their status was deemed ineligible, and that transitioned into them deciding to dissolve the entity. They're wondering, what does that mean for their application? Is it abandoned? Is it lost? I think that it's definitely a DCR question, and in my opinion, it just matters why it was deemed ineligible. And
I think what they're saying is that they were deemed ineligible because they were either within 700 square feet of another business or in an area that had reached undue concentration before their application had been processed. And so assuming that they lost the race, they kind of threw up their hands, or maybe there was an investor fight or whatever, the investors pulled out, so everything was kind of dissolved. So what do they do now? And I would assume, and this is something you would have to contact DCR about, but I would assume that there would be still an opportunity if you are the social equity applicant to, you could revive your corporation or your LLC if it was dissolved. The sort of anchor in this, the most important part about this is you as the social equity applicant. So you probably could, you know, rectify that situation in any number of ways depending on your circumstance. But it would be very fact specific.
Absolutely. And I would suggest, like I said, that first phone call you make is to DCR to find out where you stand with this. Second of all, if your investor pulled out, you're going to need another investor. You're going to have to amend your application if you're allowed to do that, because your investor pulled out. And remember, there's going to be a fee associated with any type of amendment that you make. So again, I'm sure they will look at this on a case-by-case basis to find out what the reason was. I don't see them throwing the social equity applicant or social equity individual applicant to the wolves at this point in time, since they are the body. to qualify for this license. So it's one of those things. Again, first call DCR, find yourself a good investor, I emphasize that, and start your amendment process if you're allowed to do that, and get ready to pay the fee and do what needs to be done. There's also an issue of property, because if your investor was paying for the property and they stopped paying for it, that was one of the requirements for this round one, that you had to have property. So there are a lot of factors that are going to be involved with this before moving forward.
Yeah, we actually just got some clarification from DCR on that question. And they said that you can reinstate the entity, which is what I said, you can revive the corporation, provided that it's the same social equity applicant, or you can request a modification to change the applicant entity, which means that if you wanted to just file a new company, you could do that and then request a modification.
I'm grateful DCR is listening. That is
Yeah.
a wonderful thing, isn't it? Well, DCR, since you're listening, I have an agreement that we need to go through. And it's one of those that I won't stop with it until we actually go through it. This is critical. So since you're listening, you've heard me now.
We have to continue knocking at that door so we can have the resolutions that we need to do business. I have a couple of questions in regards to phase 2 from the audience. And there's a recent deadline on July 29th. Was the last day to request a change of address for phase 2 applicants. What does that deadline mean, and what happens if the request was not submitted?
Well, I can say deadlines mean just what they say, deadlines. You know, that's why they put them there. You have to do stuff within the time frame that you've been given. That could mean that you fall into something like abandonment, or you're no longer in the running. But you have to fall within the guidelines that you've been given as it pertains to dates. Natal, you want to add any to that?
Was the question, I was reading through some of the questions. Was the question about missing the deadline for phase 2 relocation? Jasmine, are you muted?
Sorry. Yes, I heard the last day to request a change of address for phase 2 applicants was last Sunday.
So to clarify that, the last day, it actually was Monday, because the ordinance says that if it falls on a Sunday, you have till Monday. But if you needed to file a notice of intent to relocate, if you don't have temporary approval. So if you only had local authorization, had not passed an inspection or gotten temp approval, then you could file a notice of intent to relocate as of Monday. If you got temp approval already, then you will be able to request a relocation when that modification form and process becomes available here in the near future. So that's kind of the distinction there. If you fall into the first bucket where you did not pass your inspection, you missed the Monday deadline, seemingly you are in trouble, but it never hurts to call DCR, start asking them, this notice of intent to relocate. That was something that we pushed really, really hard for, because we had a lot of clients in phase 2 that had not passed inspection and really needed to relocate because they had an issue with their landlord or their location. And that was something that they made possible and made available kind of without notice and for a short period. So DCR is open, they have the power to make rules and regulations and to be fair. So if you have some sort of extenuating circumstance, some reason you didn't meet the deadline, whatever the case may be, start talking to DCR. They've extended these deadlines multiple times and it's worth a shot. Never give up.
That's right.
Yes, and just to reshare DCR's information, it's cannabis.lacity.org, and you can scroll down to their contact us and call them directly, and I believe their email is also listed. The next phase 2 question is, did the city remove phase 2 ability to add on delivery upon submission of their annual license?
This is the sad one. So if you're a tier 3, you were previously allowed, any phase 2 was previously allowed to add delivery at the time of annual. That's no longer the case. You cannot, essentially you will be able to apply for delivery sooner if you're a tier 1 or tier 2 social equity applicant. But if you are a tier 3, meaning you have a phase 2, tier 3, you'll no longer be afforded the ability to tack on that delivery at the time of annual. That was taken out of the ordinance. A lot of people were very upset about it. We had a lot of clients that were upset about it. And I think the DCR, again, to speculate, was just trying to really focus in on the social equity applicants and giving them the opportunities. But they did deprive some people of something that they had promised almost a year ago. So that's pretty controversial.
Thank you. And, you know, it sounds like there's some work applicants can do to reinstate that, because, you know, it was there once, it can come back and be reinstated. But it's going to require a lot of work and calling of elected officials, sending in emails, and knocking on that door constantly. So to wrap up, I have a couple of questions in regards to ownership. It sounds like there's some need for clarity. Can a tier 2 or tier 3 or tier 1 social equity partner upon one's, excuse me, hold on, let me read this. Okay, it sounds like, can a social equity applicant with one store with equal shares, for example, 33 1/3, potentially with a potential issue is that no one individual will have a 51% license. How can an investor find a social equity recipient to partner with if there is a list, or is there a list for these social equity qualifications in a tier 1 or tier 2? Like,
Go ahead, Jasmine.
It was a statement, but it sounds like they're asking as an investor, how can I contact social equity applicants? Where can we reach out to them as investors? How can we connect? I want to participate in the industry. What resources are available?
Okay, I understand. They're looking for equity applicants that they can engage in business with. Call me. Tell them to call me, email me, and I can connect you with social equity applicants who are looking for good investors. And I emphasize good investors who are willing to play by the rules, to follow the equity share guidelines, and do what they're supposed to do. Email me. Go to YvetteMcDowell.com.
There you go. I was just going to say, how can they get in contact?
Yeah, YvetteMcDowell.com, or they can email me at contact, CONTACT, at ymcdowell.com.
Beautiful. And Shannon, if you can drop that info on the chat, I think that would be great. The next question is, can multiple social equity partners own that 33% or 51%?
I don't think so.
No, I don't either. I've not seen that anywhere in the ordinance or anything that you can have multiple equity applicants. with that type of ownership.
Yes, social equity individual applicant, it says define, let me get you the definition by 104.20. I'm pretty sure it's just one person. I don't think that you can sort of group them together.
Yeah, I've never seen that at all in anything.
No.
Doesn't mean it can't happen. So that means you need to call DCR and ask.
Well, I think because it says it's an individual applicant, it's an individual, it's one person. And only one person can qualify. So I'm pretty sure that, and the equity share has to belong to that individual.
And I would be inclined to agree with you on that.
Okay. I think that definitely makes sense to me because
Oh, it does say you can. Oh, you can. I stand corrected. It's okay for multiple social equity individual applicants to combine to meet the requirements. That came from DCR just now.
Cool.
And I have a question from an individual who is contacting DCR as well. And their comment is DCR is stating that they are not processing license amendments until the new fee schedule is adopted by City Council. This seems unfair to licenses whose business deals will be delayed or killed as a result. Any recommendations on how to address this with DCR? It's very hard to get anyone on the phone there.
Well, DCR is listening.
Yeah,
They can respond.
So I think last Wednesday, I think it was, what day are we on? Thursday? A couple days ago, they put out notice, they're coming out with a new fee schedule. So it's coming out soon, very soon, I think. And we just need to obviously make sure that that fee schedule is fair. But I think that's going to come out. I mean, in the scope of delay in the world of cannabis licensing in Los Angeles, it's coming out very soon.
Yeah.
Yes.
And Mitchell, when DCR sent over some of the different proposed changes, they came out with the 2020 comprehensive fee study. And that's something that people can take a look at and get an idea of what these fees are going to be, because I'm pretty sure this is probably what's going to be enacted as the new fee schedule. And it will be very enlightening when you look at it.
The new fee schedule will be in council on July 29th. This is great, guys. We need to host these webinars more often. The system is under construction based on the new ordinance.
And I would encourage the audience to use this time to read the documents, read the study. Also reach out to your elected officials. There's 15 districts, and then we have Mayor Garcetti. So send them emails, send them a tweet, tell them, you know what, I need you to take a look at this fee schedule. This is what I agree with. This is what I do not agree with. This is what I, as an applicant, need from you as my elected official. Can we move this along? I mean, those relationships are so crucial because they're moving forward, making decisions that ultimately affect our business, and we have to voice our opinion.
Well said,
I have a final question, and Yvette, this is for you. It's in regards to clarification. You discuss the highest ranking officer potentially being a social equity applicant. Does the social equity applicant have to be the CEO? What are other options for the social equity applicant within those operations?
Yeah, the social equity applicant does not necessarily have to be the CEO, but because they are the 51% equity share owner, that just by operation of law and their percentages puts them in that position of the highest office holder. However, they can speak with their partner. They can negotiate that, come to some type of agreement that someone else can operate as the CEO. So they do not have to be the CEO.
Awesome. I think it's also helpful to Google. I think Google is a great resource on business structures. Just read those structures and see as an applicant what where do you see yourself? Where do you want to be positioned? And empower yourself with that knowledge. And always reach out to DCR and ask those questions.
And Jasmine, one thing I'd like to add with that quickly is if you do not feel that you are capable of taking on that particular position, be honest with yourself, because it's only going to help you in business if you come to that realization that you're not equipped to take on the role of a CEO, and find someone else that will do that. But make sure that that individual you're entering into this partnership with, giving up that type of control, make sure they're ethical. Make sure that they're going to do the right thing by you. Make sure that you have an attorney looking at that agreement as you move forward to structure that, because you do not want one of these predatory individuals taking on the role of CEO and excluding you from the major things. I cannot emphasize that enough. I'm seeing it too much. So that's just a little bit of a tidbit that I will leave with you.
Thank you. And to wrap up, what resources are available for our audience? How can our audience keep in touch with you and connect?
Thanks, Jasmine. Before we get to that, and I just wanted to get through some of these questions because I didn't want to leave people hanging. The question about processing an additional 100, Ellen, I think that they will continue until they reach that additional 100. DCR can confirm, but the question is, will they keep going through the 800 applicants until they reach 100? And I think they will, but that question is posed to DCR now. We'll see if they get a chance to respond. Let me see if there's any other new questions in here. We have a question about the notice of intent to relocate. When do we have to provide the new address? We don't know that yet. Temp approval, you can't get temp approval without having local approval. Without the state, you can use your invoice, I think, to get your state license. Just upload your invoice if you're in the top 100, where it asks for local authorization, and the state will actually call the DCR and get confirmation. So I think you're covered there. DCR says in response to Ellen's question about moving through the top 100 or an additional 100, they will identify 100 eligible applicants for further processing. So that sounds like, yes, they will keep going through until they get to the next 100. So there will be 200 invoiced applicants, regardless of how many applications they have to go through. Let's see what other questions are in here real quick. Equity can be transferred between qualified social equity individual applicants. What happens with social, the court find the if the whole program is found to be unconstitutional, we got a lot of problems, Sean. Let's see, okay. If you are not verified now, is all hope lost? No, not lost. There will be an additional window for round 2 and for delivery. For delivery, you can qualify under the old definition or the new definition. And for round 2, you have to qualify under the new definition. if you are a micro business, not social equity, can you add delivery to your temp approval? No, you have to be social equity to get delivery. Maita, my father used to say, remember, never give up. Yes.
Wise man.
Social equity applicants who have been verified but have not applied in round 1. You will be able to apply for PCN, and you will also be able to apply for delivery. For round 2, you may need to reapply if you don't meet the new definition of social equity, or you have to submit additional documentation to qualify. Yes, they did release a notice regarding the relocation deadline. Does your office work with investors? Yes, give us a call. Is this going to be recorded? Yes, this will be recorded. Great. Oh, good. Thanks, Shannon. Okay, is there any other ones that we need to get to?
Ooh, it looks like we got a lot more.
Eric, great question about the dilution of your shares as an equity shareholder. That is one of the biggest questions. We're gonna have, that's a case-by-case basis, and we're still working to figure out kind of the guidelines on that. Thank you, Hua. The application is in the, will DCR continue processing an application if the applicant is in the process of moving? Or does the applicant have to provide a new location to start? Yeah, don't move until you go through DCR. So the first step is to notify DCR of a move, and then you'll provide documentation like your lease and landlord authorization, all that stuff. Phase 2 social equity applicant has to, all delivery is now going to be applied at the new, you have to apply in the new delivery window. You can't tack it on at the annual stage, Tony. Okay, I think we got most of them. If we missed you, I'm sorry, and now we can do our plug. Yvette, where can people find you again?
Contact, CONTACT, at ymcdowell, my first initial last name, .com, or they can go to website YvetteMcDowell.com.
Thank you, and we're at manzourilaw.com. You can give us a call, 310-912-2960. Follow us on social media, 420 Attorneys.
And sign up for the newsletter. I think it's very important. Great information that comes out sometimes in the heat of the moment when things dropped at a local or state level. Great newsletter. You can find me at minoritycannabis.org or at Minority Cannabis in social media. And my name is Jasmine Aguiar. Any final thoughts, anything to wrap up, ladies?
No, thank you guys so much for joining. If you have friends that couldn't get in, I guess we were limited to only 100 people. We will make this recording available. And because of the overwhelming interest, we'll have it again. And I know that Kat Packer is planning to address commission here pretty soon. I didn't get a date on that, but pretty soon. So there'll be more information coming in. All these questions will be coming.
And the final thought that I would have is for everyone listening, if you are an equity applicant and you feel that your agreement is not following the guidelines, then have it addressed. You must deal with that. If you want to maintain the equity shares as the ordinance has put out, you must know what your agreements are all about, and do not be intimidated by your investor. You have a right to this, and just get it done. Get it done. Protect yourself, because after all, this is equity, and we want to see it be equitable.
Awesome. I want to wrap up with the importance to reach out to DCR and the importance to reach out to your elected officials and demand the changes that you need to be able to flourish in this industry. Thank you so much to everyone who joined us. If we did miss your questions, drop us a comment or shoot us an email, contact us. We look forward to reconnecting soon with a lot more information and progress from the City of Los Angeles. Thank you.
Thank you, everyone.
Thank you.